Hello everyone, welcome to my YouTube channel. Today we are going to discuss about Article 21 of the Constitution of India. So what is provided under Article 21? Here simply it is mentioned that no person shall be deprived of his life or personal liberty except according to procedure established by law. In simple word, it means the government cannot harm your life or freedom unless there is the valid fair law. This article provides protection to the person. Okay, here person means citizen, aliens, as well as any other legal person. Now we all know who are the citizen. Citizen means যিবিলাখন ভাৰতৰ নাগৰিক হয় তেওঁলোক হৈছে citizen. Then aliens means যিসকল ভাৰতৰ নাগৰিক নহয় কিন্তু তেওঁলোক আহি ভাৰতত আছে তেওঁলোক হৈছে aliens. And legal person means what? Legal person means those person যি natural person নহয়. Like human being are the natural persons, but the company is not a natural person. Company is the legal person. University is the legal person. Shopping mall is the legal person. Okay, so company, shopping mall, university তেওঁলোককো law দ্বাৰা legal personality provide কৰি দিব পাৰে তেওঁলোকক কোৱা হয় legal person. So article 21 or under protection দিয়া হয় every person, that means citizen, aliens as well as the legal person. Under Article 21, we have to discuss three important parts, that is the life, then personal liberty, and then the procedure established by law. What is the meaning of life? What is the meaning of personal liberty? As well as what is the meaning of procedure established by law? And one more thing we all have to know, that Article 21, the protection given under Article 21 is not only available against the government, but it is also available against the individual as well. কোনোবা এজন ইণ্ডিভিজুৱেলৰ এগেইনষ্ট আৰ্টিকল 21টো এভেইলেবল থাকে। আমি সকলোৱে জানো ফাণ্ডামেণ্টেল ৰাইটছ মেইনলি গভৰ্ণমেণ্ট অৰ্থাৎ ষ্টেটৰ এগেইনষ্টে এভেইলেবল থাকে। But there are certain articles like Article 17, Article 21, Article 23, Article 24. These four articles are basically available against the government as well as the individual. Then what is the meaning of life? In simple word, life does not mean just breathing or existing. আমি কেৱল উশাহ নিশাহ লৈ কিনে মানুহ হিচাপে জীয়াই আছোঁ তাকে কিন্তু লাইফ বুলি নকয়। লাইফৰ অৰ্থ হৈছে ৰাইট টু লাইফ অলছো ইনক্লুড ৰাইট টু লাইভলিহুড, ৰাইট টু ক্লিন এনভাইৰনমেণ্ট, ৰাইট টু শেল্টাৰ, ৰাইট টু হেল্থ, ৰাইট টু এডুকেশ্যন, ৰাইট টু প্ৰাইভেচি। এই সকলোবোৰ ইনক্লুডেড হয় উইদিন দ্য মিনিং অফ ৰাইট টু লাইফ। আৰু সেইকাৰণে most of the human rights are guaranteed under Article 21. Okay, most of the human rights are guaranteed under Article 21. For example, if we are talking about freedom of speech and expression, freedom of speech and expression is given under Article 19 clause 1 subclause 3. So that আমাক freedom of speech and expression কথাহে মেনশ্যন কৰা হৈছে। কিন্তু আৰ্টিকল 21ত যদিও আমি চাওঁ আৰ্টিকল 21ত চিম্পলি তিনিটা ৱৰ্ডে মেনশ্যন আছে, ৰাইট টু লাইফ, right to personal liberty, cannot be deprived of except the procedure established by law. So yet right to life for under বহুখিনি human rights included হয় আৰু যিমানবোৰ human rights include কৰা হৈছে all are came from the judicial interpretations. That means মই যদি কওঁ right to privacy, right to privacy is the part of right to life. It has been given in which judgment? It is the K.S. Puttaswamy versus Union of India AIR 2017, which case law is popularly called as the Aadhaar card case law. That our discussion kora hoisil je right to privacy is also a part of right to life. Now, what is the meaning of personal liberty? In simple word, liberty means what? Liberty means freedom. Okay, মোক কোনোৱে বাধা দিব নোৱাৰে মই এইটো কাম কৰাৰ কাৰণে। No doubt, liberty does not mean you can kill some person. Okay, you can steal a property. এইবিলাখন কিন্তু ইনক্লুডেড নহয় লিবাৰ্টিত, বাট লিবাৰ্টিৰ আণ্ডাৰত মোৰ ফ্ৰীডম আছে। কেনেকুৱা মোৰ ফ্ৰীডম আছে? টু মুভ from one place to another place, to travel from one city to another city, to live the way I want, make the personal decision, and it also protects us from the arbitrary arrest or the detention. Okay, আমি পিছলৈকে পঢ়িম ৰাইট টু মুভ বা ৰাইট টু ট্ৰেভেলৰ লগত এটা ভেৰি ফেমাছ কেছ ল আছে, ডেট ইজ দ্য মেনকা গান্ধী ভাৰ্চেছ ইউনিয়ন অফ ইণ্ডিয়া AIR 1978. We'll discuss later on. So we have to know one thing, that মোৰ কিছুমান নিজৰ লিবাৰ্টি আছে, লিগেল কাম কিছুমান কৰাৰ কাৰণে মোৰ লিবাৰ্টি আছে. ফৰ এক্সাম্পল, যিহেতু মই গুৱাহাটীত থাকোঁ, মই যদি ডিচাইড কৰোঁ যে কাইলৈ মই দিল্লীলৈকে যাম, কোনো ধৰণৰ ষ্টেট বা গভৰ্ণমেণ্টে মোক ৰেষ্ট্ৰিক্ট কৰিব নোৱাৰে কি মই দিল্লীলৈকে যাব নোৱাৰোঁ, তেনেকুৱাকৈ কোনো ধৰণৰ ৰেষ্ট্ৰিকশ্যন ইম্প'জ কৰিব নোৱাৰে. নো ডাউট দেয়াৰ আৰ চাৰ্টেন এক্সেপশ্যন. ফৰ এক্সাম্পল, ছাপ'জ মোৰ এগেইনষ্টত এটা FIR কোনোবাই মোক দিছে, অ'কে, এগেইনষ্ট মি দেয়াৰ ইজ দ্য FIR ইন আ পুলিচ ষ্টেচন. চ' ইন দিছ চিনেৰিঅ' পুলিচে মোক ক'ব পাৰে যে যিহেতু আপোনাৰ এগেইনষ্টত এটা প্ৰচিডিং ষ্টাৰ্ট হৈছে, চ' ইউ কেনট লিভ গুৱাহাটী চিটি. চ' তেনেকুৱা কিছুমান ৰেষ্ট্ৰিকশ্যন ইম্প'জ কৰিব পাৰে, বাট ইউজুৱেলি no one can put restriction on me to move from Guwahati to Delhi. Same goes to traveling as well, as same goes to the personal decision as well. And here the personal liberty also protect us from arbitrary arrest or the detention. What is the meaning of arbitrary arrest? Arbitrary arrest means suppose police without any reason, without any lawful ground আমাক arrest কৰিব নোৱাৰে. In case of the cognizable offenses, পুলিচৰ তাত ৱাৰেণ্ট থাকিব লাগিব, অৰ্থাৎ মেজিষ্ট্ৰেটৰ পৰা অৰ্ডাৰ আনিব লাগিব আপোনাক এৰেষ্ট কৰাৰ কাৰণে. যদি কোনো ধৰণৰ লফুল গ্ৰাউণ্ড নোহোৱা স্বত্তেও যদি আমাক এৰেষ্ট কৰিবলগীয়া আছে, দেন ইট উইল বি টাৰ্ম এজ দ্য আৰ্বিট্ৰেৰী এৰেষ্ট. অ'কে, দেন Article 21 protect us from the arbitrary arrest as well. Article 21 is called as the heart of the Constitution. Why? Because it protects our dignity, our freedom, our choice, our privacy, as well as our basic quality of life. And that's why Article 21 is called as the heart of the Constitution, because it almost every human right flows from Article 21. And human rights or karne Magna Carta ka kua hoy, human rights or karne Magna Carta কোৱা হয় Universal Declaration on Human Rights, which was signed on 10th December 1948. 1948 চনৰ 10 ডিচেম্বৰ দিনাখন ইউনিভাৰ্চেল ডিক্লাৰেশ্যন অন হিউমেন ৰাইটছ চাইন কৰা হৈছিলে, আৰু ইয়াত সৰ্বমুঠ 30টা আৰ্টিকল আছে, আৰু এই 30টা আৰ্টিকলছত হিউমেনৰ বেচিক ৰাইটছখিনি প্ৰভাইড কৰা হৈছে. নাও ডিছকাশ্যন কৰিবলৈকে ওলাইছোঁ some of the very important landmark case law under Article 21. Okay, first of all, we have A.K. Gopalan versus State of Madras. The judgment was given in the year of 1950. Here, A.K. Gopalan, who was the communist leader, he was arrested under the Preventive Detention Act of 1950, and that's why A.K. Gopalan challenged the decision of his arrest. And he mentioned that his arrest was violative of Article 21 and Article 14. Okay, but what was the judgment given in this case law? The court upheld the Preventive Detention Act as the constitutional. Okay, it declared that Section 14 of the Act, which the Preventive Detention Act of 1950, which prohibited disclosing grounds for detention in court, unconstitutional. Now here the judgment given in this case law was thoroughly criticized because it simply gave a narrow interpretation to the personal liberty. But later on, the decision given in this case law was overruled by Menoka Gandhi case law. Now let's start with one of the most important case law under Article 21, that is Menoka Gandhi versus Union of India AIR 1978. Here, the passport of Menoka Gandhi was impounded under Section 10 of the Passport Act. Okay, so because of it, Menoka Gandhi challenged such kind of the decision, and she mentioned that such kind of the impounding of her passport is violative of Article 14, Article 19, and Article 21 of the Constitution of India. Remember, these three articles together called as the golden article of the Constitution of India. Okay, So here in this case law, the meaning of procedure established by law got a better interpretation. Okay, procedure must be just, fair and reasonable. So moving to this part, let's discuss what is the meaning of procedure established by law. Next important case law is Francis Corelli Mullin versus the Union Territory of Delhi, where in the judgment it was decided that life includes the right to live with dignity, not mere animal existence. জীৱ-জন্তুৰ দৰে অকল এক্সিষ্টেঞ্চ নহয়, জীয়াই থকা মানে আমি live with dignity to included হয় under Article 21 of the Constitution of India. Then we have a fourth important case law, that is the Bandhua Mukti Morcha versus Union of India, AIR 1984, where in the judgment of this case law it was decided that right to dignity includes freedom from bonded labor. Next important case law is Toliga Tellis versus Bombay Municipal Corporation. The judgment was given in the year of 1985. Here the judgment is that right to livelihood is the part of the right to life. This was the judgment given under Article 21 of the Constitution of India. Sixth important case law is related with the right to clean environment. So under Article 21, we also have the right to clean environment. Okay. So here the very important case law is Subhas Kumar versus State of Bihar, AIR 1991. Here the judgment was that right to pollution free water and air is included under Article 21. So Subhas Kumar case law is very important whenever we are studying the environmental law. Okay, this case law is very important. Then we have MC Mehta versus Union of India. Under since MC Mehta is the very famous Supreme Court lawyer, and most of the time তেওঁ PIL-ৰ থ্ৰুইদি অৰ্থাৎ পাব্লিক ইণ্টাৰেষ্ট লিটিগেশ্যনৰ থ্ৰুইদি আণ্ডাৰ আৰ্টিকল 32 হওক বা আণ্ডাৰ আৰ্টিকল 226 হওক তেখেতে বহুখিনি PIL ফাইল কৰিছে আৰু তাৰ ভিতৰত বহুখিনি কেছ আছে এনভাইৰনমেণ্টেল লত আমি থৰলি ডিছকাশ্যন কৰিম some of the very famous case law are Ganga pollution case, oleum case, leak case, etc. Okay. Then we have this case law. This is the very important case law, that is K.S. Puttaswamy versus Union of India, and the judgment was given in the year of 2017. So here it was decided that right to privacy as the fundamental right. So this case law is also called as the Aadhaar card case law. So Aadhaar cardot আমি যেতিয়া বায়োডাটা দিওঁ তেতিয়াহ'লে বায়োডাটা দিলে আমাৰ পাৰ্চনেল ডাটাখিনিও দিয়া হয় সো পাৰ্চনেল ডাটা যেতিয়া আমি দিওঁ তেতিয়া আমাৰ ৰাইট টু প্ৰাইভেচি ভায়োলেট হয় সো ইয়াতে কোৱা হৈছিলে যে ৰাইট টু প্ৰাইভেচি ইজ আৱাৰ ফাণ্ডামেণ্টেল ৰাইট Then we have D.K. Basu versus State of West Bengal. This case law is very important relating to the right against the illegal detention. So, যদি এজন পুলিচে আহি মানুহ এজনক বা কোনোবা এজন একিউজ পাৰ্চনক যদি এৰেষ্ট কৰিবলৈকে লয় সেই সময়ত কিছুমান গাইডলাইন আছে সুপ্ৰিম কোৰ্টে এই কেছ লটোত দিছিলে আৰু সেই গাইডলাইনখিনি তেওঁলোকে ফলো কৰিবই লাগিব ষ্ট্ৰিক্টলি ফৰ এক্সাম্পল তেওঁ নিজৰ নাম প্লেট দেখুৱাব লাগিব ফেমিলি মেম্বাৰ হওক বা ৰিলেটিভছক ইনফৰ্ম কৰিব লাগিব তেনেকুৱাকৈ বহুখিনি guideline দিয়া হৈছিলে DK Basu versus State of West Bengal, and this case law is very important relating to the CRPC as well as BNSS, Bharatiya Nagarik Suraksha Sanghita. Then we have Sunil Batra versus Delhi Administration, AIR 1978, where it was decided that prisoner rights are also protected under Article 21. Prisoners are also included within the meaning of person. Okay. Prisoners are also the citizen. That's why since the Article 21 provides the right to life and personal liberty to all person, so here prisoners are also included. Then we have a very famous case law, that is the Husainera Khatun versus State of Bihar, AIR 1979, where it was declared that free legal aid and speedy trial are the part of Article 21, and this judgment was reaffirmed in the case law, that is the Kartar Singh versus State of Punjab, AIR 1994. Then relating to the right to die with dignity, we have very famous case law, that is the Oruna Sanvok case, AIR 2011, where passive euthanasia with condition was allowed. So euthanasia means what? Suppose a person is suffering from incurable disease, okay, and because of it he or she is suffering from severe pain. In this scenario, what she or he can do, he or she can end his life. Usually suicide করার অধিকার কারো নাই। Okay, so, attempt to suicide earlier it was punishable, but right now under BNS it is not punishable, but still suicide করার কারো অধিকাৰ নাথাকে। কিন্তু কোনোবা এজন পাৰ্চন যদি ইনকিউৰেবল ডিজিজত ছাফাৰিং কৰি থকাৰ কাৰণে বহুখিনি চিভিয়াৰ পেইন ফেচ কৰি আছে, ইন দিছ চিনেৰিঅ' তেওঁ নিজৰ লাইফটো এণ্ড কৰিব পাৰে। এণ্ড লেটাৰ অন দিছ কনচেপ্ট ৰাইট টু ডাই উইথ ডিগনিটি ৱাজ লেটাৰ expanded in this very famous case law, that is Common Cause versus Union of India 2018, where it has been held that right to die with dignity is the part of Article 21. A case law to AJS examot বহুত repeatedly ahi thake. Then relating to the right to shelter, we have Shamili Singh versus State of UP AR 1996, where it has been decided that right to shelter is included under the right to life. Then relating to right to education, we have Mohini Jain versus State of Karnataka 1992, where right to education has been recognized as the part under Article 21. Then we have Punni Krishnan versus State of Andhra Pradesh AR 1993. Okay, and later on in the year of 2002, 86th Amendment Act was passed, and through it to Article 21 another article was inserted, that is Article 21A, which specifically deals with the right to education. Under the right to health, Paschim Banga Khet Mazboor Samiti versus State of West Bengal AIR 1996, where it has been held that right to health and medical care is the part of Article 21. So this is all about Article 21. If you like the video, please like, share and comment it. Thank you everyone.